You've been listening to Donna Nelson, a DNA expert on the stand, talking about some of the DNA that was found on a number of items that were in the car Tremaine Wilbourn was the passenger in the night of the shooting. I'm joined in studio today by two guests. Double the fun here in the studio. I have Ross Kramer, criminal defense attorney, with me, Bob Schalk, criminal defense attorney and former assistant district attorney. So we were just talking about this witness and why she was even called to testify, because Wilbourn isn't even disputing the fact that he was there that night. So why do we need her to say that his DNA is on these items that were found in the car? And Ross, you raised a good point that this is juror expectations, you said, in 2018.
Yeah, I mean, this is an age of jurors that was raised on CSI and SVU and shows that make people believe that the way you prove a case is that there's DNA and fingerprints everywhere, this kind of forensic evidence that you can really touch and put your hands on. So here I think they're just trying to close a loophole. Now there's nothing a defense attorney can argue that he wasn't in the car. Now there's nothing that a juror could have in the back of his mind. Why isn't there DNA evidence here? Why haven't I heard anything about fingerprints? It's really just going overboard. They don't need it to prove this part of the case, but I think they want to do it just to make sure they have everything.
Yeah.
Yeah, I mean, I would agree in the sense of when I was prosecuting cases, the first thing you learn on trying murder cases and things of the like is bury the jury with evidence. Make them hear every single shred, because you don't know what each individual jurors are expecting to hear or what they want to hear, because they're dealing with the highest charge that someone could be charged with. It's a capital offense. You don't, for someone to say guilty and for someone to potentially say he's going to get the death penalty, they want to know 100% certainty throughout the case, this is the guy, we're doing the right thing, etc., or not. Right. And the last thing you want to have as a prosecutor is to be standing there during summations and having the defense attorney say to a jury, why didn't you hear about DNA and fingerprinting?
That's
and
a good point. I mean, you don't want to cut corners, particularly with a capital case. And I do think it is interesting in this age of true crime and not true crime, you know, on Law and Order, SVU, all of that people are used to. They are, you know, everyone's used to hearing about DNA in every case. So let's go back now and see what the witness is testifying on. Quick sidebar going on there. The witness on the stand, Ms. Nelson, said there were 6 DNA swabs from the carjacked vehicle, including the steering wheel. So we're not just talking about the vehicle in which Wilbourn was a passenger the night that he allegedly shot and killed Sean Bolton, but also the car that he then stole at gunpoint just a little while later. It's an interesting case for sure, because I think of that extra angle. Right, gentlemen? Not only did Tremaine Wilbourn admittedly shoot and kill this officer, though he says it was an accident, but then ran off, held someone at gunpoint and said, I need your car, I just killed a cop. We know he's already serving 28 years for that. The jury, knowing about the carjacking, I mean, does this, in your mind, as criminal defense attorneys, I mean, how much worse does this make an already pretty tough case? I
would say this obviously is going to be the argument that the prosecutor's going to make his consciousness of guilt. He knew he just committed a crime and was fleeing from that crime. And by doing the carjacking, it's a continuation of, he knew that he had just committed the worst kind of crime you could commit. This wasn't an accident. I had to get out of there. If this is an accident, you're staying behind.
I think he also made a statement to the carjacking victim, right?
Yeah, I just shot a police officer. I just shot a cop. Right?
Yeah, and that's why I need this car. I mean, this is a narrative that it's so powerful for the prosecutors to establish here. What happened on this night from the minute that police officer shined his light through the window of the car all the way through the end of that night. It really tells a cohesive story, and it's going to be very, very difficult for the defendant.
Yeah, I mean, and earlier today, jurors did hear the 911 call when the carjacker called 911, and they heard from the carjacking victim as well, so they're going to be getting a pretty full picture about the events that went on that night. You know, I want to get into Wilbourn's defense just for a moment, since you both are criminal defense attorneys. I mean, the fact that he's saying it was an accident, he grabbed his gun, but he didn't mean to fire. When the officer has, you know, when we have an autopsy, when we have a medical examiner saying he was shot 8 times, does that argument fly?
It's very difficult, and you have to also look at where he was shot. And you heard the testimony, I believe it was yesterday, the day before, of his responding brother officers saying, he was shot in the face, and his face, when we rolled him over, pretty much fell apart as we rolled him over. How is it an accident when, one, there's that many shots, and two, they're in the most critical locations on a body? If someone's wearing a vest, the only place you're going to kill somebody and to shoot them is in the head, and he shoots him directly in the face. I mean, that's a very difficult argument to make to a jury.
Yeah, Ross, would you go with this? It was an accident defense?
You know, I thought a very interesting little piece of the trial that could be easy to overlook is when the defendant yelled and people testified that, you know, turn on your cameras. People, look what's going on here. So, you know, in opening statements that was shut down, but it's going to be able to come in as to his state of mind if he takes the stand here, and that's going to be a very interesting argument.
Well, I want to talk about that angle, the fact that there were perhaps fears in this community about interactions with police, and I also certainly want to talk about Wilbourn himself taking the stand. First, we're going to take a quick break, and we're going to come back. We're going to have much more analysis on this trial. Stay with us. All right, welcome back to Law&Crime Trial Network. Thanks for being with us this afternoon. The Tremaine Wilbourn case now on a quick 15-minute break. The DNA expert that was on the stand apparently had some slides to show, but there were some technical issues going on in the courtroom with regards to the projector. So while they get that sorted out, I'm here live in studio with my two guests this afternoon, Ross Kramer, criminal defense attorney, Bob Schalk, also criminal defense attorney and a former assistant district attorney. Right before we went to break, Ross had raised the point. We're talking about Wilbourn's defense, how he's saying that this was an accident. But it is true that right when the cop showed up, when the police officer showed up, shone the light into the car that night, Officer Bolton, and that Wilbourn shouted out, and the neighbors heard him say, "Get your cameras out, they're killing us." Now, as you mentioned, the defense attorney tried to bring this into his opening statements, that was because just a month prior, in the Memphis Police Department, a young unarmed black man had been killed by an officer. So tensions perhaps were high, fears perhaps were running deep, but you know, and although that was shut down in opening arguments, yes, I do think we're going to hear it again as testimony continues. I mean, what can we make of this, that he said everyone will get your cameras out, suggesting he was perhaps worried that the cop might try to assault him or hurt him? Bob, do you want to start with that one?
Yeah, I mean, you're making reference to Darius Stewart was killed by a Memphis police officer, and he was yelling about it. As you indicated, the lawyer tried to open up on it, and even though it was shot down and the judge said disregard that, I always like to say that's the toothpaste is already out of the tube. You can't put it back in. The jury heard it. They know that name. They know who he is. And you're going to hear the defendant indicated yesterday that he was going to be testifying. He's going to get into this. He's going to talk about his fears and potential racial tensions going on between police officers and young African Americans. The issue that I think you're going to run into with regards to that argument is that the officer's gun was never drawn. It's not like he showed up with the gun drawn and he yanked him out of the car and they're struggling over a gun and it happens like that. It appears as if, you know, he's yelling that in an intention to draw attention to himself. So if something did happen, but he was the, you know, appears based upon the testimony of the aggressor here. So it'll be interesting to see how that testimony plays out and kind of how he comes across. Right. It's all going to depend on how the defendant testifies.
And there are actually, I should correct myself, some questions as to whether, in fact, he said they're killing us, get your cameras out, they're killing us, or just said get your cameras out. Ross, what do you think about the fact that the jurors have heard this? You know, perhaps many of them have experienced this themselves, fear in an interaction with a police officer.
I mean, I think it's a really interesting argument. I think we're going to start seeing things like this all over the country because this is not a Memphis issue. This is a nationwide issue now. And in all of these crimes, someone's intent to cause harm or to cause death is really the central issue here. It's not what happened. It's what was going through someone's mind. We look at these cases where police officers are doing the shooting, and it's what was in their mind. Were they reasonably trying to protect themselves? Were they trying to protect the public? At this point in time, is a reasonable African-American man who's pulled over by an aggressive police officer who grabs him and throws him out of a car. What was in his mind at that time? Was he using reasonable force to defend himself? I don't think it would be successful in a case. I think there are a lot of hurdles you have to overcome, like the gun in this case, like the number of shots, like the spacing between the shots, and also like the fact they set it up that this was an accident. I don't understand how accident jives with the fact that he was worried about being attacked, so he shot back. But I think it's a really interesting argument, and I'm interested to see how it develops over time and whether judges allow it to even be made.
Yeah. Right, but also remember, they may not necessarily be going for the full-on acquittal here. There could be a hung jury, and all you need is one. And that lawyer could be playing towards one jury of the 12 that he picked. Okay, who are we identifying as our jurors to potentially hang this jury? Because remember, the state would have to retry the case all over again if it's a hung jury. It has to be a unanimous decision. So at times, lawyers are still fighting the uphill battle of, it may be difficult to acquit my client, but if I can hone in on that one juror, those two jurors who are potentially see it the way that I'm arguing it, those are the ones he's focusing on. Those are the ones the lawyers want to go after, hang the case, and either new counsel will try it the second time. And there's a saying in our businesses that their retrial is always to the benefit of the defense, because they've now tried certain arguments. They've tried, they've seen the prosecution's
hand. They've seen what's worked, they've seen what hasn't.
Right. You know what's interesting here is, to follow on that, it's not just that they're playing for a potential hung jury, but they're also playing to the same jury that's going to hear a penalty phase.
Right.
So you're setting up arguments, and in the penalty phase, it's the rules of evidence are much more wide open, and you're allowed to bring in a lot of mitigating circumstances.
That was my thought. I mean, yeah, like you said, maybe they're not going for an acquittal. This guy's already serving 28 years behind bars now for the carjacking and the gun charges. So, I mean, maybe they figure at least if they can save his life, that's something at this point. While we wait for court to resume, because again, they are just on a short break, should resume in just about 10 minutes, we do want to go back to some earlier testimony we heard. Remember, when this shooting happened, it all happened rather quickly. It was a chaotic scene, and Officer Bolton's colleagues were trying to reach him, were trying to find him, weren't quite sure what had happened. Let's hear now from Lawana Stamp. She's the police radio dispatcher who was frantically trying to get in touch with Officer Bolton just after these shots were fired. So there you have it. Marquis Wright, an eyewitness to this shooting, was literally standing right there in his uncle's driveway, right where the car was parked on the street when he saw this shooting happen. Ross Kramer, criminal defense attorney, and Bob Schalk, also a criminal defense attorney, still in studio with me. I mean, clearly it helps the prosecution's case to have someone who saw it all go down. Ross?
Yeah, I mean, I think there's just a tiny bit of daylight there with the way the officer acted and what the state of mind might have been for the defendant in the car. You know, this witness doesn't say that the officer went up and asked him to step out of the car. He grabbed him and pulled him out of the car. He initiated this physical altercation. He put himself very close to the defendant, and they started wrestling. I mean, I think there's just a little bit of a chance that some juror here will say, I understand, maybe this wasn't first-degree murder because maybe he had a legitimate fear for his own safety in this confrontation.
Interesting argument. I mean, Bob, do you agree? Now, let's remember that the driver of this car had just taken off running. So I would imagine if you're a cop, you think, okay, these guys have done something wrong when one guy takes off running. At least that's probably what the argument would be.
Right. It would be, exigent circumstances, emergency circumstances. I have someone fleeing from the scene. I'm now going to ascertain what's in that vehicle. Is it a danger to me? Is that person a danger to me? Obviously, we're not going to hear the testimony of the officer, but obviously you can assume, and they're going to argue, the prosecution should argue, listen, he's coming into a chaotic scene of someone running down the street, fleeing from a police officer. Again, that consciousness of guilt that we talked about earlier. Secondarily to that, you also have a scenario where it would make so much more sense if it was the officer's gun that was accidentally pulled out, or they were struggling, if the officer had drawn his weapon. But this guy's, carrying an illegal firearm. They do have an altercation, and he steps right back and starts firing. I mean, it appears. So, and again, consider where he shot him. Shoots him in the face. Shoots him almost 10 shots discharged, 8 hitting him from close range. If
I was a defense attorney here, I would consider calling an expert in police procedure, and we saw that in the Van Dyke case in Chicago. Because here, I don't know that this is correct police procedure. Why didn't that officer stand back out of arm's length, pull his own gun, and order the guy out of the car and onto the ground? Why did he provoke a physical altercation here? And if you get an expert who says this was totally inappropriate on behalf of the officer, and there's a reason because it escalates violence, maybe you widen that gap just a little bit.
That's a great point. I mean, you have individuals who, have friends and family in law enforcement, or have had good or bad experiences on this jury with law enforcement. If you bring in an expert that's just completely taken aback from this situation, who doesn't work in that police department, who's just there to say, listen, this is standard protocol and procedure. This is how it is instilled in the police academy, and it doesn't follow the lines of proper procedure. you have that possibility of maybe this isn't a murder one, or two, I'm going to hang this jury or something like that.
Yeah, I mean, and there is a good chance perhaps we will hear an expert witness like that when the defense starts their case next week.
Yep.
We don't know for sure. Want to talk more about the defense's case and Wilbourn's desire to testify, but first we want to go back to some more of the testimony we heard earlier from Lawana Stamps, the police radio dispatcher. The clip we're about to hear is her talking about the point she realized something had gone wrong.
34.
Officer Jacoba Boyd, a colleague of Officer Bolton's in the Memphis Police Department, getting emotional on the stand. I mean, this happened 3 years ago, but of course, when he's shown the photos of the crime scene and asked to describe the injuries, I'm sure it all comes back to him. And there were a number of sort of graphic and emotional pieces of testimony about the physical condition of Officer Bolton when the other first responders finally found him. When you hear things like his face was falling apart, I mean, that's really graphic and gruesome and disturbing for jurors, which, of course, plays to the prosecutor's advantage, right, Bob?
Listen, when you are sworn in as a juror, the judge tells you day one when he gets your initial instructions, and on the very last day before you start your deliberations, that you have to check your emotions at the door, and you're not allowed to play on people's emotions. But anyone who just listens to that testimony can't sit there and say that that's not emotional. And every juror brings their life's experiences and their emotions into the courtroom. I guarantee you that there have been jurors crying, or that will cry throughout the course of this case at some point in time. Having first responders testify is always to the benefit of the prosecution, because they're going to lay out a scene, a horrific scene in this situation where you're talking about a police officer's face who got blown to bits, where they tried doing CPR, they had to cover a bullet hole in his throat so that the air wouldn't escape that way, and then more or less he was lifeless when they got there. Any juror who hears that is going to feel the emotion of it, and it's very difficult for a defense attorney to get there and cross-examine that, because there comes a point in time of what am I going to accomplish by cross-examining him, and most times defense attorneys say, I have no questions for this witness. So again, very powerful emotional stuff, which obviously goes to the benefit of the prosecution.
Would you ask that witness any questions, Ross?
Well, look, I think that this is obviously a powerful witness for the prosecution, but at the end of the day, I don't think that this kind of testimony is going to carry the conviction here. Things like how many shots were fired, whether there was any spacing between the shots, and really what was in the defendant's mind at the time. At the end of the day, I think when the jury goes back to deliberate, there are going to be bigger issues than what the first responders saw, because I think at the end of the day, a juror knows that a gun causes terrible damage to a human body, and it's horrible what happened. I think what's really interesting here, and you see this in this trial, and you also see it in the case that your viewers are seeing with the baby, is these kind of cases take a tremendous toll, not only on the victim and their family, but everybody here.
I'm glad you brought that up, because for those who maybe were not watching this afternoon, we know that in that case, the Zachary Keene case, horrific child abuse case, so tough for all of us to listen to. Zachary Keene himself on the stand this morning, that after that, one of the jurors basically had a breakdown, told the judge they were melting down, and the judge dismissed that juror. And it made me think about, we always talk about, oh, what's it like for the witnesses to have to recount everything they experienced? What about the jurors? I mean, is there ever any, counseling offered to the jurors after these trials, or is it just, hey, thanks for your service, good luck, hope you don't have flashbacks of this the rest of your life,
I mean, these are terrible experiences for jurors. They're terrible experiences for the lawyers that are involved. A prosecutor who has to sit with victims, look at autopsy pictures. Sometimes, bodies have to be exhumed, and lawyers live with this for years. So, I mean, there's so many people in these cases that it's incredibly hard for, not just the first responders, not just the victim and their family, although those are the primary victims. When these kind of things happen, there's a whole orbit of people around that are traumatized by this. Sex crimes prosecutors often have very short stints in that unit because of the things they hear, and they just can't do it for a long time.
Yeah, it's very difficult in the sense that you can sit there on jury selection, which is the most important part of a criminal case, and say to them, ladies and gentlemen, you are going to hear things that you would never thought you'd hear. You're going to see things that you never thought you'd see. And if you can't handle it, let us know now. And a lot of times jurors will raise their hand and say, I can't do this.
Yeah.
Emotionally, I can't do it. I'm telling you now, don't pick me. And they don't get picked. But there are times where jurors think they can handle it, but they're not seeing the pictures in advance. They're not hearing the testimony in advance. When you talk about a 2-year-old child that they're saying was malnourished in the same diaper for potentially up to 2.
A 4-month-old. You know, think about.
Sorry, right, 4 months,
you know,
not
I'm
the
only
sister
correcting
was
you
2.
because you know, yeah, the sister was 2. A 2-year-old could maybe express themselves a little bit more, walk
But a
around.
4-month-old in a diaper that was for, you know, and you're hearing
2
about
weeks.
the smells and the scenes and see the photos. It's horrific.
Well, it's certainly an interesting discussion, the impact that these cases have on the jurors. Gentlemen, stay right here. We're going to take a quick break. We'll be right back. The medical examiner, Marko Ross, continues his testimony. You see the diagram up there that shows all of the bullet entry wounds on Officer Bolton's body. My guests here still in studio with me, Ross Kramer and Bob Schalk. Let me ask you both, when we look at that diagram alone, I mean, we were discussing perhaps the most interesting part are the bullet wounds that entered from the back of the officer's body, right? So how did Tremaine Wilbourn shoot him? You know, where was the officer when this happened? Bob, your thoughts on that and what that says to the jury?
Right, you also see some defensive wounds, which is indicative of there was one right here on the wrist of his hand, which is usually he's putting his hands up, or at that point in time, he potentially was on his chest. The entry wounds from the back are indicative that obviously he got hit once, rolled over onto his front, probably holding his face, because that's what the officer said, that when they found him the first time and the man smoking the cigarette, and the individual used his radio, said that when they came out, they had to roll him over. Again, it just spits in the face of the defense of this was an accident, because it appears as if as he's falling to the ground and rolling over, shots are still being fired. Not just being fired, but being fired at the locations on his body where he's not protected.
Right.
His legs, his arms, his neck, his clavicle, etc. So, I mean, the medical examiner's testimony, the only way I see the defense really getting into much is with regards, maybe they have trajectories, which is indicative that, you know, the defendant was potentially falling backwards, because if you've never shot a gun before and you have a gun with a very quick trigger, once you put your finger on it, the bullets come fast and furious. You know, when I worked at the DA's office, we got to shoot with the police officers. So that's the first time you really feel it for the first time. If he's falling backwards and pulling that trigger pretty quickly, he could say it was accidental. I didn't anticipate it. It's all going to boil down to his testimony, which we've been saying all day.
Yeah, I mean, what can we make, Ross, of the medical examiner's testimony, his opinion at least, that Officer Bolton would have survived if he had only been shot that one time? The bullet that went into his jaw went down, re-entered through his collarbone. Some fragments wound up in his chest. But what do we make of that? Him saying, you know, if it had only been shot this one time, probably could have saved his life.
I mean, I think it's a really tough testimony for a defense to overcome, because it's never really the first shot in the struggle, because then you have the opportunity to argue self-defense, that he perceived that he was in danger, and that's why he fired that first shot, to open up space between him and who he saw as an assailant. But it's those next 7 hits, it's the hits on the back of his legs. I think the defense may cross-examine here and may have to sum up on the idea that, you know, when you're in a gunfight like this, when you're in this kind of street fight, that it's just so frenetic and it's so fast. You know, a lot of times people don't even realize how many shots they fired, and you'll see this even from police officers. This could even be another subject for an expert to look at. Police officers sometimes will fire, you know, multiple shots and have no recollection of how many shots they took, because everything is happening so fast, and it's really hard to slow down there and figure out what's going on and parse it out. That's what they're trying to have this medical examiner do.
Yeah, and interesting to note, the judge said to the courtroom, if the family members want to leave, go ahead and leave now. These photos are going to be graphic. We're told most actually stayed in there. Again, Law&Crime opting not to show those photos, but from what I'm seeing online and from reporters who are in the courtroom, as you might imagine, they're very tough to look at. We're going to take a quick break, but first I want to thank you, Bob, for being with us this afternoon. I know you have to leave us, but we appreciate your insight as always. Ross is sticking around. We're going to take a quick break. We'll be back with much more live out of Memphis, Tennessee. Stay with us. So Dr. Marko Ross continuing to testify about the autopsy photos, the extent of the injuries that Officer Bolton suffered. You know, here in studio, Ross and I are just talking about, okay, well, this has been going on a little while now, and you have to imagine some of the jurors perhaps are starting to tune out. Okay, we heard the interesting stuff about where the bullet wounds entered, how far perhaps Wilbourn was standing, which was closer than 3 to 4 feet, according to Dr. Ross. You know, they saw the photos, we saw the diagram. What's this guy still talking about? But you raise a very good point that, once again, we got to cross all the T's, dot all the I's, and get to the minutia.
Yeah, it's a tough job that prosecutors have with a witness like this, because they're not trying to win the case while this guy's on the witness stand, but they're trying to get all of this key information in so that at summation, when they're pulling all the scattered pieces of this trial together, they could tell a cohesive story without any holes to jurors about how this individual died. And so there is still a balance, because you can't have jurors falling asleep in the courtroom. This is supposed to be very important testimony, but jurors are told by judges, by prosecutors, in opening statements and jury instructions, don't make up your mind until all of the evidence is in. It's going to come in scattered pieces, and at the end of the trial, that's when you start deliberating after the lawyers have told you how to put all these pieces together. So jurors, right now, we're going to have trouble parsing out the important parts here, but hopefully a good prosecutor at the end of the day will be able to give them the roadmap to make sense of this testimony.
Yeah, well, good explanation there for sure. Thank you, Ross. We're going to take another quick break, but stay with us. Much more live in the Tremaine Wilbourn trial coming up right after this. All right, welcome back. We're having some audio issues in the Memphis, Tennessee courtroom where Dr. Marko Ross, the medical examiner, is still on the stand talking about Officer Bolton's injuries. So while we wait for that to come back, I want to quickly ask you, Ross, about the fact that Tremaine Wilbourn, his attorneys have said from the beginning that he is going to testify. Right, a couple minutes ago we were talking about, well, this medical examiner testimony is getting boring. I have a feeling once he's on the stand, no one is going to tune out. Does he, in a case like this where he's saying he felt threatened and it was an accident, does he have to take the stand to get jurors to see that?
So the conventional wisdom is, as a defense lawyer, is that you prepare the defendant, but unless you're way behind at the end of the prosecution's case, you usually don't put the defendant on the stand, because it's a very risky proposition. You don't want to win and lose with how likable this one individual is as opposed to the rest of the case. In this case, the defense may be so far behind the 8 ball by the time they get to the end of the prosecution's case. It's one of those Hail Marys where you try to pull anything out of your hat. If the defendant testifies, if he's believable, if he's credible, if he comes across as the kind of person where a jury could believe he felt threatened or something else happened here, this might not be a first-degree murder charge, which is, I think, his only goal here.
Yeah, I mean, is it unusual that they promised it up front?
You know, we're seeing more and more of that here at Law&Crime, but I think it's a mistake to do that, because then you're kind of backed into a corner. You know, you leave yourself open for making promises that jurors remember and then not fulfilling them at the end. You can still get out of it, because a defense lawyer can still say at the end of the day, look, I thought that there was going to be so much more evidence against my client, I thought he would need to testify in his own defense, and that's why I raised that to you. At the end of the day, it turns out the way the evidence came in, he doesn't need to testify. We can rely on the presumption of innocence. I don't think that's going to be the case here. I think he probably will have to testify, or will choose to testify.
Yeah. Well, we will certainly stay tuned for that. Let's go back inside now where cross-examination of Dr. Marko Ross has begun. So Dr. Marko Ross, the medical examiner, under cross-examination there. I just want to, Ross, pick up the conversation we were having before I sign off about Wilbourn himself testifying. You know, to me, the biggest question is how is he going to answer the question on cross-examination? Or perhaps the defense will do it up front, you know, about why he fired so many times and why when this officer, as we're hearing the medical examiner testify, why when Officer Bolton was face down.
Yeah, I mean, this is what the defense team theoretically has been working on for a long time and putting together the pieces. What you do as a defense lawyer and a defense team with a defendant is you take the pieces of evidence and the facts you have and you try to craft a narrative that makes sense. So here, you know, you have witnesses saying that there was the statement that, you know, everybody turn on your phones, so get what's going on. You have the blue flashing lights that pull up, one person running out of the car, and a cop who is apparently very aggressive and tried to grab this, you know, large defendant out of the car without any warning. I would think that the defense is gonna say, and the defendant's gonna say on the stand, you know, this was the heat of the moment. I have no idea how many shots I fired. I felt my life was in danger as a black man faced at night with a white police officer who didn't give me any warning, who didn't give me any time to surrender, but grabbed me out of a vehicle. And you know, I was fighting for my life there, and that's all I saw. Everything else happened in a flash, and then when I realized what happened, I took off. I think that's going to be his best shot, and if he says it in a way that resonates with even one juror, it's going to be a successful testimony.
Yeah, I'm getting the sense from you, and maybe this is just the defense attorney in you, right? Getting a sense that you believe maybe he does have a shot, at least, you know, getting a lesser charge.
I don't think it's going to turn out that way. I think he's going to be convicted here. Just hearing how the prosecution is assembling this case, hearing how many shots, where those shots entered from, you know, the whole host of evidence that's coming in here. But I think it's an interesting defense, and a lot of times when you're forced to trial in a capital murder case, you have almost no defense. You really just have to rely on the presumption of innocence and the burden of proof that's on the prosecutors. Here, I think there's at least an interesting story. And every time you're hoping to get an acquittal, it's because you have some kind of story and you have some kind of narrative that's going to resonate with jurors. And I think at least here, the defense has something to work with.
Yeah. I mean, the way you describe it, you know what I mean? You sort of convinced me a little bit. Maybe he will. It looks like the medical examiner wrapped up his testimony, and that perhaps we're getting ready for another break here, or maybe they're wrapping up for the day. It's very possible. It is almost 5 o'clock. Any closing thoughts on this trial that you wanted to mention that I didn't ask you about, Ross, or did we cover it all?
No, I mean, I think we covered certainly what we had today. I'm really glad that we stuck with this trial as opposed to the other one that's going on right now, which is
it's tough.
And in the same way, like we talked about before, I mean, just devastating for everyone involved. That's you know, there it's these pictures of a child who passed away. Here it's a police officer who was killed in the line of duty. These are traumatic cases for everyone involved, but. Of the two, I'll stick with this one and give you some commentary on this one.
Yeah, I mean, it's always hard, I think, with these horrific cases to, you know, to rank which one is worse than the other, right? You know, all tragic for sure. But I want to thank you so much for being here as always, and your insight. It was very helpful, so we enjoyed having you on, and hope to see you back here again. Thank you so much, Ross. Well, that is going to do it for me here on the Law and Crime Network. But of course, don't go anywhere. We're not done for the day. Aaron Keller coming up with the Daily Debrief. He will have much more on this case out of Memphis, Tennessee. He'll have more on the Zachary Keene case, so stick around. Aaron Keller coming up with the Daily Debrief right after this.